The last topic related to choice of forum that we're going to discuss is known as forum nonconvenience. Now, I had a lot of material prepared on forum nonconvenience, but we're going to leave it alone because it's a very complex part of the law. What forum nonconvenience says is that sometimes, even where a court has jurisdiction and the venue is proper, the court can refuse to hear the case if it believes that there is a more appropriate forum available elsewhere. So when we talk about forum nonconvenience, the thing you need to know is that it is the power of a court to refuse to hear a case even where hearing the case is appropriate, even where jurisdiction is present and venue is proper. A court may sometimes refuse to hear a case. Now, the reason this doctrine exists is the belief that some litigants engage in what's called forum shopping, meaning they will look for the most appropriate forum to hear the case, even where there's a better, more appropriate forum elsewhere. So in order to prevent this notion of forum shopping, courts have created a doctrine that says that under certain circumstances, a court can refuse to hear a case. The final topic in this lecture is about choice of law. And again, there's a lot we could say about choice of law, but we're not going to do so because it would take simply too much time and too much energy. I understand that in most commercial contracts, the parties will make an affirmative choice of applicable law. This is the best practice for any party engaged in international commerce, is to make sure that in the contract itself, the choice of law is set out, because courts will respect the contractual choice of law. So understand that choice of law is important, and it's important enough that it should be decided well in advance. Now, if the choice of law selection is not made, then we are faced with a question that's known as conflict of laws analysis. And what conflict of laws analysis does is try to determine what is the most appropriate law to be applied in this dispute. Now, conflict of laws rules, again, we're not going to study them because they're some of the most complex rules in the law. But in general, courts will apply the law of the state that has the closest relationship to the dispute. And that's true whether that's within the United States or within the world. What country has the closest relationship to the action at hand? And once again, it might depend on the nature of the dispute. For instance, in a contractual dispute for contracts, the dispute should be determined by the law of the jurisdiction that has the most significant relationship to the transaction. For torts, the dispute should be determined by the law of the place where the injury occurred. Nevertheless, for the most part, you as future business people should be encouraged to include a choice of law clause in all international contracts. Choice of law clauses are contractual provisions that dictate the country or the jurisdiction whose law will apply in the event of a dispute. And in fact, this choice of law should be something that comes up in early negotiation of a contract. It's not something that should be left to the end of contract negotiations. So choice of law, something that you can choose, and as future business people, you should choose.